Good afternoon, folks. This is John Berger coming to you from high atop ACERL World Headquarters in beautiful sunny Atlanta, Georgia on this November day. I'm happy to see the sun after 4 straight days of rain. I hope it is as pleasant where you are as it is here. I'm very pleased to welcome back Marianne Burright and Stephen Wilson from the University of Georgia for the second in a 3-part series around principles of contracting. Excited to have them back and to see so many folks in the room. Before I hand it over to them, I have to do a little bit of housekeeping. Apologies for those of you who have heard this many times, but basically the way it works is that you can hear us, but we can't hear you. So if you want to have a conversation with somebody or your phone rings or something, don't worry about it. You're not disturbing the rest of the group. If you do have a question or a comment, you can communicate with us in one of 2 ways. On your little e-meeting panel, which probably has shrunk down to just a little tiny little rectangle in the upper right-hand corner of your screen, the arrows are now orange. You can click on that. It'll pop back open and enter your questions to me via the chat box. If it's something that I can answer, I'll tap it right back to you. If it's something that needs Stephen or Marianne's intervention, I will ask them at an appropriate time. The other option is you can raise your hand. That will flag me, and I can turn your audio on one by one, and you can ask your question that way. Either one will work. So future webinars, as I mentioned a second ago, this is the second in the 3-part series. The third part will be December 11th at 2 o'clock Eastern, Essentials of a Publication Agreement. We are also in the middle of an ongoing series of show and tell webinars around digital scholarship activity, member libraries. Some of you may realize that the session number 4 was supposed to happen on Tuesday of this week, and we had to reschedule it because a speaker got sick. So that has just been rescheduled, is now out of sequence, but that's been rescheduled for December 19th. We also have session number 5 on December 5th. Session 6 on December 14th, so it's a busy month for webinars. And for those of you who are involved with the Scholars Trust Print Journal Retention Project, our second of 2 annual or biannual town hall meetings is set for December 12th. As always, these sessions are being recorded and will be posted to our website under a Creative Commons license. You see the URL there, acerl.org/archive. And if you have other suggestions or ideas for future topics, or you want to volunteer to be a speaker, by all means, drop me a line at jberger@acerl.org. One last piece of housekeeping is a reminder about the ACERL Code of Conduct. It's basically the play well with others rule. Please, no harassment, in-line, on-person, or other sorts of unwelcome verbal comments, nonverbal expressions, or other behaviors. If you feel you have been mistreated, by all means, report it to me or an ACERL board member, either when it is occurring or afterwards is okay. The reports are confidential. And as you see there, ACERL has a couple of options on how to deal with those situations. And we've never had any problems at any events online or online or in person, so we want to keep it that way and make sure the expectations are clear. That's it for me. So once again, I'm very pleased to welcome Marianne Burright and Stephen Wilson from the University of Georgia. Tossed it to you guys. There you are in sort of work mode. And presentation mode. Very good. Take it away, guys. Thanks so much for being with us.
Hi, everybody. It's Stephen Wolfson here. Thank you for listening to us today. I've got Marianne Burright in the office with me, and so we'll sort of switch off on the microphone as we do. So it's nice to have everybody back here so we can talk a little bit about license agreements. It's been a dreary week here in Georgia, but today is very nice and bright, so it's nice to remember what that's looking like. So here's a nice picture of a tree. But moving on from that, I want to review just for a second about what we spoke about the previous session, just because it will inform a little bit about what we talk about today. So if you were here last time, or if you weren't, we talked a little bit about what makes a legally enforceable contract. So a legally enforceable contract is basically a promise that the court is going to enforce. Okay, not all contracts are promises, but not all promises are contracts is the message there. An enforceable contract must have 3 elements: offer, acceptance, and consideration. Consideration is often the most confusing topic for a lot of people, including first-year law students. The idea behind this is that it's a bargain for exchange. It's the thing that the parties agreed to give up in exchange for their promises. And then finally, and this is particularly important for what we're going to be talking about today, is that when there's a written document, that means when the parties have decided to draft their contract in written form, courts are going to look to that first, and very often only, to determine what the agreement includes.
Happy Friday, everyone. I'm really happy to see the sun again. Let me tell you about that. Anyway, so for today, we're going to talk about learning goals. Oops, I went too far. Sorry about that. So we're going to basically walk you through a number of key aspects of provisions in a license agreement, such as for you to be able to recognize what the section headings look like, what they're called, typical language that each provision would use, also the purpose of each provision and how they each allocate risk to the contracting parties. Also part of the language analysis a bit, we're going to talk about what qualifiers and standards of performance are. Qualifiers are words that limit the scope of language or make it broader, and standards of performance are those words that basically tell the person signing the license what they're responsible for, and also what the promisor is responsible for and how well they expect to carry that promise out. So onto building blocks. We've grouped each types of provisions into certain categories that include introductory provisions, which are basically the preambles, recitals, and who's agreeing, who's entering this contract, why, and how they came to get there. We talk about definitions and defined terms. And so as you probably know, if you're signing contracts for your institution, you've seen a section of definitions, and basically they are there to let each party know exactly what they mean that they're agreeing to. Action sections is where pretty much all the action happens. It's all the action verbs, who's doing what, how, under what conditions, and when. And finally, the end game and general provisions include those clauses that deal with how will this agreement end, if it's a renewable license, of course, how and when does it renew, if it does auto renew. And finally, we talk about the boilerplate provisions, which to my mind, they're not quite as boilerplate as most people would think. There's variation and moving parts depending on what state you're in and so forth. So I just want to, by way of review again, in terms of core contracting principles, we talked about that the enforceable contract creates a legal obligation for the party making that promise. And so on the flip side of that promise and obligation that's being made, the party receiving, receives a right. So you promise something, the person that you're promising receives a legal right to be able to enforce that should you breach. So an example here is a database vendor X is promising library Y access to back file of a journal in perpetuity. So this is what a promise sounds like. Basically, what does perpetuity mean is that, what would happen if, let's say, the library canceled their current subscription? Do they get to keep the back file of the journal? Or let's say there's a natural disaster, and what happens? Is there a backup server that the promisor maintains, so the library would eventually have still access to that back file, and so forth. So contracts create levels of risk allocation to each contracting party. So there's always going to be two sides to the transaction. One is the one that's promising the action. The other side is the one that receives the action, and the risk is allocated between the two. The next concept is that the promisor is the master of the contract, meaning the party that drafts the contract has the higher negotiating power just simply because they are drafting, they have the service to offer. They're in control of the language. And let's reflect for a moment on what that means for us as librarians, as the customers. The question that we want to ask is, how much negotiation power do we have? And that brings us to the next bullet point, which is if you're the non-drafting party, such as mostly that is the position that libraries are in, you may have some leeway to negotiate with some of the provisions that we're going to talk about, but that negotiation power is somewhat limited. But there is an ability to negotiate over choice of law and, you know, what court system to use should there be a breach.
So I'm going to talk a little bit about the first sections that you'll usually see in a contract here. So before we get into that a little bit, though, I want to talk about some just general tips about reading contracts. So it's like anything else, any other long document. It's always smart to break down long sentences and long sections into pieces, and we're going to do that along the way as we look at sort of a sample contract. Also, don't be intimidated by legalese. You might see a lot of like heretofores and other words, even some Latin occasionally. Usually that stuff is just thrown in there because of that's how contracts have been written for the past 150 years or whatever. But don't feel intimidated by them, and in fact, instead, just kind of accept them for what they are, which is kind of outdated provisions or outdated language, and then move past them. Like I said, the best thing you can do is break down sections into smaller chunks to understand them better. But let's talk about the preambles and the recitals. So these are usually the first things you'll see in a contract. And again, we're going to show you some specific examples as we go along. So these preambles, they set the stage for an agreement. So a lot of times they'll say, this is what we're agreeing to. These are the parties, things like this. I think the most important thing about this section, which you're going to hear me say a lot, is don't overlook it, right? This is still part of the agreement, even though it's not the section that you're probably going to be looking to really understand what both of the parties are promising to. It's still part of the contract, so don't overlook it. So this is not the license agreement that you might individually agree to at a university, but this is the terms of use that you can find on EBSCO's website, right? And this is just the first chunk of from the license agreement. And you can see the section that I circled here is what we're talking about as far as the preambles. Let's break that out into what it says specifically, right? So it says by using the services available at this site or by making the services available, you agree to comply with these terms and conditions. So it's really easy. It's just setting up what the rest of the document is going to be. It says by using this, you are now a party to it. So the second section we're going to talk about that Marianne already addressed briefly is the definition section. So again, as I said, I'm going to say several times, don't overlook these things. So the definition section is just what it sounds like. So you can define terms that you use within an agreement sort of however you want. You can say, that for the purposes of this agreement, black means blue or whatever. It doesn't really matter. But the important thing to know for you as somebody who's reading these agreements is to pay attention to these things and understand how terms are going to be defined for the rest of the agreement, right? And once again, don't overlook this. So we're going to see what this looks like in the EBSCO agreement. So again, I've got this circled, and you've got this big, huge chunk of text that's just, I don't know about you, but my eyes glaze over a little bit as I try to read this. So let's break it out into each of its parts. So again, for purposes of this agreement, EBSCO is the name of their company, right? But where we get into more interesting things here, like, for instance, authorized users, right? So the authorized users under this terms of use agreement include employees, students, yada, yada, yada. What I think is really interesting is that it specifically it unincludes alumni because they recognize that they don't want to extend this to alumni. So as far as the contract defines, an authorized user does not include alumni. It also defines the services and then, of course, the databases as we go along. I also want to address disclaimers. So disclaimers are things you'll see very frequently. You've signed plenty in your life. So disclaimers are just things that say, we're not going to be liable for this for whatever reason. It's things that the person who's making the promise doesn't want to take on the legal liability for. It's really common in academic databases to disclaim like the accuracy of content, or whether that content is says something inflammatory or something that somebody likes. Essentially what a disclaimer is saying that if you see something on our database that you don't like, you can't come and complain to us about it, right? We told you that we don't stand up for anything that's on here, we just give you access to it. And again, you're always going to see these, and frequently at the beginning of the contract. So this is the same chunk of text. I've got this section, circled here, but let's break that out. So EBSCO disclaims any liability for the accuracy, completeness, or functionality of the material complaint contained herein, right? So anything here, we don't care if we're not saying it's accurate, we're not saying that we agree with any of the content, we're just giving it to you, right? And I do want to point out, as you read through this, you'll see at the end that this agreement, which again, this is just online, you can just pull this freely off of their website. It does have a typo. I found this, that there's two periods at the end of the last sentence. I find it funny that they left it in there, but I wanted to point that out sort of as a teaching moment, that even big professional contracts can have small or even substantial errors in them. So you want to keep your eyes open while reading these things. I mean, a double period is not a big deal, but you want to keep your eyes open for more substantive errors as you read along.
Okay, so next we talk about the action sections. And basically that grouping of provisions under the action sections outlines what each party will take responsibility to do, and that includes basically the consideration. In other words, what are they exchanging? Are they exchanging money? Are they exchanging non-financial obligations like performance, doing something? In the action sections, you'll want to follow the cash, if you will, such as who's paying whom, how much, when, how, and what triggers the payment. In terms of a license agreement, what is the relationship of the contracting parties? What is the actual date or anniversary term for the license to end? And be aware of what's called evergreen provisions, which auto-renew. In other words, what are the notification rules if one party wants to end the auto renewing of that particular license? So the major sections of the action sections include representations and warranties, and I'm sure many of you have already seen or are familiar with these headings, but let's kind of step through them and talk about what each one really means. So representations, a representation is a statement of past or present truth. So let's say I'm selling my car to Stephen, and Stephen really wants a blue car, and I'm saying I represent that my car that I'm selling to you, Stephen, is blue. Okay, so it's an actual statement of what is happening at this particular moment. The warranty is that I warrant that the car is blue, meaning I'm guaranteeing the truth of that statement, and there are two different legal standards. Next is covenants, which are promises. The promise creates a legal obligation, and the language for that is shall. So I say, I shall sell my blue car to Stephen. Okay. Conditions generally are marked with an if-then statement, and they deal with, they always have to be tied to another provision. So it's a condition to what? You always have to kind of ask yourself, is this a condition to Stephen's payment may be conditioned upon the car being blue. If it's red, he's not going to pay me. So it must relate to some sort of an action provision. Discretionary authority is important because it gives permission or choice for the party, either party, to be able to do something. And the language used there is may. I may not paint over my blue car to sell to Stephen. There's also a negative, discretionary authority. I may or may not. It's a choice or a permission, and it's not dispositive. So you may have that choice, but it doesn't exclude other things from happening. And then finally, in the action sections, we have what's called declarations. And these are statements that basically define how the contracting parties will interact with each other. It's basically like the policy statement of the contract. So let's first talk about representations and warranties, which you'll probably see in any license agreement that you may have signed or have read for your institution. So basically, a contract translates a business transaction, the selling of something, a licensing of something, into legal obligations and rights for the parties. And each provision, as we talked about before, creates some sort of risk allocation. So what I mean by that specifically is when I promise to do something, I promise to keep my car painted blue, that shifts the risk, the legal risk for me to keep that car painted blue. If I paint it red and Stephen doesn't want a red car, then, you know, he can collect damages, for example. Okay, a contract has to be read in its entirety to know what are the moving parts. So say, for example, you get a particular grant of certain set of rights in one portion of it, but then later on, the drafting party will put some limits on that. So you have to be kind of careful and read through, are those rights that are being granted remaining the same throughout the contract? Again, let's talk a bit about representations and warranties. So representation is a fact statement about present or past condition in a particular moment of time, and it's intended to induce reliance. What that means in terms of inducing reliance, it basically means that if I say I'm selling a blue car and Stephen really wants a blue car, I'm basically, you know, drawing him into that sale. By saying it's a blue car and he really wants that, I'm kind of luring him into that sale. Okay. A warranty, on the other hand, is the guarantee of the truth of that statement that I'm making. And good drafting, a good contract, when you read it, will put representations and warranties under one section together, because these are two different legal standards. And kind of a sloppily written contract may put them in two different sections, but that invites trouble because you're creating two different legal standards. Okay, so let's kind of look through some examples here from the APA, American Psychological Association. The APA represents and warrants that, to the best of the APA's knowledge, the licensed material used as contemplated by this license agreement do not infringe the copyright or any other proprietary or intellectual property rights of any third party. The qualifier here, remember we talked about different kinds of words like qualifiers and standards of performance. Qualifiers are those words that set limits, that limit the scope of language to create a certain standard of expectation. An example of that is to the best of the APA's knowledge. So I think we have a poll that's been created. I think John worked on these slides. So let's see if that works. So the question here is saying, to the best of APA's knowledge, is that a broad or a narrow qualifier, do you think?
Folks, please make your choices. About a third of you have voted. I'll count it down. 5, 4, 3, 2, 1. Close it, and then share it. Marianne?
Okay, what do I do? Sorry, John, what do I do to be able to share it?
Are you now seeing it on your slide? I think you are. Are you not seeing the results of the poll?
No.
I don't know why that is. Let's see. Poll results enable screen sharing. Got it now? Are you seeing it now?
No. Should I move forward
Okay,
a slide or?
I will at least tell you what the results are. Sorry, folks. The folks from the audience are saying they are seeing it.
Oh, okay.
So the results are the respondents, 77% said they felt it was a broad qualifier, 9% thought it was a narrow qualifier, and 14% didn't know or wasn't sure.
Okay. All right. So the majority has it. It's definitely a broad qualifier to say to the best of a knowledge standard is pretty broad. And the reason why is because it says the best of APA's knowledge. It doesn't restrict that to, let's say, APA's board of directors and CFO. So in other words, it's saying the entire APA. It doesn't really put limits on whose knowledge. And the next question is, whom does this benefit? Does it benefit the APA or the licensee? And that is our second poll question.
So folks, there you are. You should be seeing the poll. So 72% have voted. 5, 4, 3, 2, 1. This is a pretty clear winner here. 100% of you said that you felt like that that clause benefited the APA, not the licensee.
No, actually, it benefits the licensee. And Stephen, holler if you disagree with me. Do you? Oh, he doesn't disagree with me. Okay. So I'm just kind of curious. Could maybe somebody type in the chat box why they thought it benefits the APA? And of course, I can't see what you're typing in, so John will have to tell me.
So the chat box, folks, if you want to provide a little bit of feedback, you can come up through there. Marianne, I had another poll, or another question for this slide. The question about do not infringe or any other licensee does not infringe the copyright or any other property or intellectual property rights. Do we want to do that one?
Yeah. I just want to get back to whom does it benefit, the APA or licensee? Is there any answer to that from the audience?
There a couple of folks have typed in. One person said is because they, presumably the APA can deny knowing anything, and they, presumably the APA, are held blameless.
I personally would read that as benefiting the licensee, and maybe this is up for debate, but I read it to mean that the APA is setting itself up for a pretty high, broad kind of bar by saying to the best of all of our organization's knowledge, there is no, the licensed material does not infringe. And again, does not infringe, that's a pretty blank statement. It's an absolute qualifier. There is no infringement whatsoever or any other proprietary or intellectual property rights. So I take that to mean that the licensee is the beneficiary of that qualifying language. And Stephen, do you want to say anything about this? He doesn't.
A couple of more comments have come in. One person saying that since it is a broad statement, almost anything would fall within it. And then another person notes, I get why you think it benefits the licensee. That means the licensee can't be sued for infringement since APA warranted it.
Well, that's where reading the entire contract will really be useful, because even though this is a pretty broad warrant and representation for the APA to make for itself, now, if you are reading the rest of the contract, does the APA further limit this broadness? So, that's something where an entire contract would have to be looked at. Does that kind of get at the question?
I think so.
Okay.
Do we want to do the third poll about the infringements?
Oh, yes. Let's go ahead and do that.
So the statement about does not infringe. And I'm sorry that our system doesn't allow you to see the slide and the poll at the same time.
Mm-hmm.
So about 40% of you have voted. 5, 4, 3, 2, 1. And I see that there's a typo in there. Sorry, folks. I've been working with my board, so you see why it says board and not broad. Do not infringe or any. Is this a broad or narrow qualifier? Well, there's several typos. Bad day. 30% said broad, 35% said narrow, and 35% wasn't sure, didn't know.
Okay, it's pretty broad. And the reason why I say that is because it's a flat qualifier. It's absolute. It just simply says do not infringe. Our material used does not infringe the copyright or any other proprietary or intellectual property right. So it's not putting any limits or specific limiting scope on the infringement or the kind of proprietary or IP rights. So it means copyright, trademark, patents if there's anything. So it's kind of like the kitchen sink. It's pretty broad language.
Before we move off of this slide, another question came in. Who would be held liable for copyright infringement under this agreement? APA or the licensee?
I can address that if you want.
Stephen wants to address that.
Well, so as I mentioned in our last session, it's going to depend. So if your question is who will be liable for copyright infringement within the document that's on that APA is making available, that's likely to be the person who did the copying initially, though I can't say for sure because, again, there's going to be a world of facts that's going to help answer that. Or if you're talking about copyright infringement by the user, like by me, if I'm using what APA has provided for me, it's still going to be a problem is still going to be with what I'm doing, my conduct. The point here is that APA is like a third party to this, right? So they are saying that we are not liable for it. You can figure out on your end who's liable for it, but it's not us.
Okay.
Oh,
go ahead.
Yeah, I was going to say, why don't we come back to this because I know we're at 35 minutes and you still have some more stuff to cover, so we'll come back to this question.
Okay, sounds good. Okay, so next I want to talk about standards of performance. We talked about qualifiers, which is language that we just examined that limits the scope of liability or makes it broad, The flip side of that, there's also what's called standards of performance, which are basically statements that say how well will a promisor follow through on what it's promising. So remember that the drafting party is writing your standard of performance. Each of those provisions has a symmetry to it. There's going to be provisions that are aimed at for the drafting party, and they're going to be symmetrical, to the non-drafting party. And the drafting party, of course, is likely to benefit itself, make its standards of performance maybe lower, so it has less expectations to live up to and less legal liability than perhaps the standards that it will set for the non-drafting party or the licensee. And again, the standard of performance is going to always be tied to legal liability that the promisor takes on. So let's talk about the actual language here for the standards. When we say a good faith effort, I know I didn't do a poll for this, and I've already put the answer up there. So let's just kind of move through that. A good faith effort is kind of low. It's a low bar. It's just above fraud. Reasonable effort is middle of the road. A best effort is kind of the highest standard. Okay. So good faith effort, next higher up, reasonable effort, the highest is best effort. Sometimes defined by industry standards also. So all of these words are kind of very open to interpretation. And when courts have a dispute in front of them about what these words mean, they may look to the standards that are available in that particular industry. So what does it mean to really resolve a technical issue, for a database vendor? That would be looked at by what typically vendors or publishers do. Also keep in mind that you are going to be on one side or the other of the transaction, and to be mindful of what is the standard of performance that you're going to agree to. Okay, continuing on with another example from reps and warranties, which is a pretty important section, so that's why I'm kind of really drilling down on this. Also from the APA license, licensee represents and warrants that it will use reasonable endeavors to notify authorized users of the terms and conditions of this license agreement and use best efforts to protect the licensed material from unauthorized use or other breach of this license agreement. So let's think about what's wrong with saying reasonable endeavors to notify. This is kind of a discussion question that I really didn't put into a poll because the poll are only yes or no answers or multiple choice, but this is something for you to kind of think about and maybe jot down in the chat box or make a note to yourself so we can discuss later if you want to send in questions for John. But think about what it's really saying. The licensee is the library. It's saying the library or the licensee represents and warrants that it will use reasonable endeavors to notify authorized users and use best efforts to protect the licensed material. I mean, do we all as librarians kind of use reasonable efforts to notify our authorized users of the terms of our licenses? That's pretty high, folks. So kind of think about what the language says. Also, that goes for the best effort to protect standard, to protecting the licensed material from unauthorized use or other breach. That's also pretty high standard that the APA is setting up for the licensee. Okay, another technicality.
Marianne, can I jump in?
Yeah.
Yeah, there's a couple of comments here saying either you notify or you don't notify. Using best efforts to notify makes no sense.
That's a great comment.
Around reasonable efforts to notify is a low bar, but best efforts to protect is a high bar, so they are not proportionally weighted.
Yes, that's exactly right. That's exactly right. There's something in particularly wrong with this provision. It represents and warrants that it will use. Can anybody kind of think of what's wrong with this and type it into the chat box for John to read to me?
Feedback, folks, about it will use. One person noted that there is no start date on this.
Okay, not quite what I was looking for. The point is that representations and warranties deal with present or past statements of fact. This is talking about represents and warrants about something in the future. Future actions are covenants, which are promises. So, the writing of this is off kilter because it's using one type of provision, representations and warranties, to really talk about covenants, which is a different legal standard. So, I just wanted to bring your attention that it's kind of mixing two different legal standards into one. Okay, the next thing is covenants, which is really an important provision because that's where the promisor is taking on promising the action of what they're going to do. And the operative language there is shall, or shall not. Those are action verbs. A lot of licenses kind of mix different languages and it's very confusing, but the point I'm trying to make here is when you're reading through a license, look for verbs that deal with the future, like what is the licensor going to do? That's their promise, that's their covenant. That is the legal standard that they're obligating themselves to do. Okay. Moving on, the reason why covenants are important is because that's where remedies flow from this provision. Essentially what that means is, this is if the covenant or the promise is breached by the party that makes it, that's what you're, as the licensee, sue on. That's where you get the damages, you get the money remedy. Let's take a look at another one. Licensee agrees to indemnify and hold harmless the APA, its directors, its officers, employees, successors, and assigns from and against any claims, actions, or demands arising from a breach of this license agreement or from a third-party claim of infringement due to derivative work created by licensee and or authorized user, or due to an unauthorized use of the licensed materials by licensee or authorized user. And before I go into the poll, how many people are still awake after I just read that? Okay, I'm hoping everyone's still awake. Okay, great. So the poll question is this a broad or narrow standard for the licensee? Remember, this is requiring the licensee, that means the library, to do something.
Folks, poll is up. Is this a broad or narrow standard? And about a third of you have voted. Numbers are jumping around. All right, I'll say 5, 4, 3, 2, 1. So is this a broad or narrow standard? 29% thought it was a broad standard. 47% said it was a narrow standard. 18% said neither, and 66% said both.
Did you say 66 or 6 said both?
No, 6.
Oh, okay.
6.
Well, to my mind, I read it as both, okay? And I'll tell you why. Because it is broad in the sense that it indemnify and hold harmless the APA and all these other folks in the APA and its assigns and successors. So that's a lot of grouping here. So that's broad. From actions or demands arising from a breach by third parties, all that before the bolded words is pretty broad. But when you come down to what are they holding the APA harmless from, it's due to the derivative work created. It's only that subset of things, the derivative work created by the licensee and authorized user. So it's a pretty small kind of piece of the pie. So I read that as being broad at first and then it further narrows. So I read it as both, and you know, if there are a lot of English majors out there, this is like, you guys should be having a field day, because we're dealing with language and interpretation. Stephen, do you have any, nothing to add? Okay. All right. So I'm going to keep moving forward, and we can come back to this as questions at the end if we have time. So conditions, these are if-then statements that attach to a particular provision, whether it's a covenant or you know, a representation and warranty or what have you. Here, the example. I know we're running out of time, so I'll probably have to just give you the answer to that one. If the APA identifies any unauthorized use of the licensed material in breach of this license agreement, the APA has the right to immediately terminate access under this license agreement for the offending IP address until the breach is corrected. The APA and licensee agree that they will work together to correct the breach as soon as possible so that access can be restored. And my question is, whom does the condition obligate? You want to, let's just run. Yeah, let's do the poll.
Do the poll?
Yeah, we'll do it quickly this time.
Okay. Whom does this condition obligate? To correct the breach. APA, the licensee, neither or both. About a third of you have voted. 5, 4, 3, 2, 1. 11% felt it obligated the APA to correct the breach. 39% felt like it was the licensee's responsibility. 6% said it was neither party's responsibility. And 44% said it was both parties' responsibilities.
I read it as both. Again, this is kind of ambiguous, so it needs more interpretive analysis to it. But I read it as both because of the language that goes to APA and licensee agree that they will work together to correct the breach. How easy or difficult is this to satisfy? I would say it's kind of difficult because the APA is setting itself up for an ambiguous statement. Work together. You know, what does work together mean? So with that, I'm going to move on to the next because I know we're getting short on time. So next is discretionary authority. Discretionary authority is a permission or choice for a party to be able to do something. It's not dispositive, which means it doesn't foreclose other options. It's a good tool for negotiating when you are the non-drafting party, but be aware that you know, too many conditions and too much discretionary authority may bog down a transaction. One of the examples that I noted here, again from the APA, is under the section heading confidential information. And it says, notwithstanding the foregoing, each party may disclose confidential information. And the foregoing refers to the section before it where it says, you know, we, the APA, are not going to disclose confidential information. But here the language says each party may, and that's discretionary authority. So let's say if there's some sort of law enforcement order for the licensee to disclose confidential information about who clicked on which articles, you know, the license is giving the library or the licensee that choice to comply with the court order or not. Next is that this is kind of a good leveraging negotiation tool for the libraries or the licensee to be able to say, I want more discretionary authority, and kind of negotiate using that. But again, be aware that it could bog things down. Lastly is declarations in the action sections, which are basically rules that govern the transaction between the contracting parties that deal with how will they communicate with each other, how often will they communicate, and so on. They're important, but they're not as important as covenants because no remedies come out of this provision. You can't sue on declarations, like, you know, if you ask them to use email, but they sent you something by Federal Express. You know, you're not going to get money damages if there's a breach in declarations. So a recap: reps and warranties are true statements of past or present. Covenants are promises. Very important, they use the word shall, something that will occur in the future. Conditions are if then, they relate to action provisions, they attach to something. Discretionary authority gives a choice to the party, uses the word may, and declarations are contract management policies. So on to Stephen.
All right, we're going to finish this up pretty quickly here and then hopefully have a little time for questions at the end. So we're going to talk a little bit about sort of the end of the contract and some boilerplate provisions. So boilerplate, these are things you're going to see in almost every agreement, almost every professionally written agreement. They look almost identical. And once again, you don't want to overlook these. It's sometimes easy to because they sort of come off as like white noise. But again, read the whole agreement because it's important. But as far as like sort of the provisions that tend to be toward the end of the agreement. So you'll see termination provisions. So these are things that regulate or explain what happens in case of a breach and or how to break the agreement. We'll take a look at an example, but basically it'll say, you know, if there's a breach, then this happens, or maybe there's this way to remedy the breach, or this is a way for the contract entirely to end. Act of God provisions is probably my favorite provision in a contract. These are things that usually are disclaimed in case of what are called quote-unquote acts of God. You can imagine this like a natural disaster. So EBSCO, if there's a natural disaster that knocks out their servers, you can't come complain to them that you can't use their services because of this act of God provision. Again, we're going to look at this in just a second. Severability provisions are quite important. So there are some standards in sort of the history of contract law that would say that if one provision in a contract is broken, is deemed to be invalid by a court, then the whole contract falls apart. And nobody likes that. And so very frequently, in fact, in almost every professionally written contract, you'll see a provision that says something to the extent of, even if one of the provisions of this contract is deemed to be invalid, the whole rest of the contract stands. Again, you're always going to regularly going to see these, and that's all it really means. And then things like choice of law, choice of venue provisions. And these are provisions that will say if a lawsuit does in fact arise under the terms of this agreement, then you have to bring the lawsuit in X state, and you have to follow the laws. They'll be following the laws of whatever that state is usually. So let's look a little bit at examples from the same example we were looking at earlier. So this is a termination agreement. And what I find interesting about this is that it specifically builds into a way for the licensee, that would be, you know, the users, to remedy in case of a breach. And in fact, asks them to try to remedy before the contract falls apart. I think that's really interesting. We can also see this act of God provision that says, you know, EBSCO nor its licensors, you know, is liable for all of these things, you know, acts of God, war, riot, embargoes, yada, yada, yada. You can imagine, you know, again, like a hurricane knocks down, you know, power, and so you can't use their services. Assignment, frequently you'll see assignment provisions that will regulate whether or not the contract can be given to somebody else, and a lot of times it's going to shut that sort of thing down, which is what it does here. And then severability, as we mentioned, it's going to, you know, in case one part of this is invalid, the whole contract still stands. Then the whole agreement provision. Now, I mentioned earlier, and we mentioned in the last time, that if the contract is boiled down to a writing, which is what we're talking about, written documents here, then frequently you'll see a provision that says that if that's true, then this is the whole agreement and nothing else from external. None of our email conversations or anything counts towards the meaning of this agreement. Now, it's still theoretically possible to bring some of that stuff in, but generally these provisions are going to stand, and it's going to say, again, this is the whole agreement. There's no other agreements besides this one and things that are incorporated into it. So just a quick summary before we're done here. Remember the building blocks of a typical license are these things: introduction, action sequences, and then the end game. You want to be aware of which side of the transaction you're on, and then what sides, what risk you're allocating from one side to the other. Remember that the drafting party generally has control over the licenses, but sometimes you may have some leverage in negotiating some provisions. It's going to depend on what the provision is and who you are as part of this agreement, but you may have some leverage, and if nothing else is fair to ask the question. So at this point, we're willing to take any questions that you may have. In addition, if you have any questions that we don't answer today, you can always email either of us, and here are our email addresses.
Thanks, y'all. A question came in a couple of minutes ago is, what about indemnification clauses? I always get questions about that.
So do you want to know what an indemnification clause is, or what the validity of it is? The answer is it's perfectly valid. What it is it's basically saying somebody is not at fault for whatever is what they generally mean.
Yeah, I think what I'm inferring is why are they so troublesome?
Why are they troublesome? I think it's just because people don't like them, because they don't like being told that somebody is not, you can't go after somebody for something. I think that it sort of may rub people the wrong way when you see that sort of thing. But there's going to be indemnification clauses in every single professional contract you read.
And the question about, I'm still not sure why we need to care about broad or narrow provisions. What are the implications?
Okay, so the implication is basically the legal liability that a party takes on when they're drafting, let's say for themselves, a broad or a narrow. It's a set of expectations that you're setting yourself up for. So if you're setting yourself up for something broad that you have to live up to, you're taking on more liability that you can get sued for bigger damages. If you are the drafting party and you set yourself up for something narrow, you narrow the scope of what you're taking on, then, you will not be responsible for bigger damages if you're sued. Does that make sense? And Stephen, if you want to weigh in.
I think what you said is correct. I mean, I think that the point that Marianne was making mainly is to be aware of these things, to understand sort of the scope of what the agreements are. And frequently, that scope is not always like immediately clear. It takes a bit of sort of reasoning to figure that out.
And the last question, can we go back to what's wrong with reasonable efforts to notify?
So I wanted to throw in just one mention to that. Usually reasonable efforts to notify, a lot of times that's referring to like a sign. So you might imagine that you put up a sign that says, like when you log onto onto a website, it says like you can't use this for nefarious purposes. That would be like a reasonable effort to notify rather than specific notification, which is grabbing each user and telling them you can't use this for nefarious purposes. Does that make sense?
Yeah, I think people were wondering about, there seemed to be some comments back and forth about whether a good faith effort or a reasonable effort, what should you agree to when it comes to something like notification?
Well, just going back, a good faith effort is a standard that's below the reasonable. What was troubling me in particular personally about this provision is that it was expecting the licensee to go out and notify, to use reasonable efforts, which is a bit higher than a good faith effort to notify its users, its authorized users about, how to use the data in the database. It seems kind of like an expectation for the licensee to be more proactive rather than reactive if some breach occurred. So I felt like it was putting more expectation on the licensee than necessary.
And then follow up on indemnification. FYI, some public institutions, for example, in Virginia, cannot sign indemnification clauses by state law. We routinely strike them and include standard state procurement riders that nullify them. Vendors typically accept this since they and we have no choice. I'm not sure if other states have similar requirements.
Yeah, that's very common for state institutions to not accept indemnification clauses. My point was only that these are going to be everywhere. I mean, they're just sort of built in. They're almost like boilerplate provisions, which is to say that you agree to take on liability in X, in X situations or whatever like that. But yes, it's extremely common for state institutions to not accept that liability.
Very good, folks. Thanks for sticking with us for a couple minutes over, and for a couple of minor technical hiccups with the polling. Want to again thank Marianne and Stephen for their time today. We have another session coming up in another couple of weeks. The registration links are available on the ACERL website if you would like to do so. So I think we're done for today, folks. It's a sunny Friday afternoon. Thanks, everybody, for your time. This is John Berger signing off. Take care and have a good weekend.